laws, which is the IPC or the CrPC, are now, and the Indian Evidence Act have been replaced by the Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Suraksha Sanhita, and the BSA. These are long names, and you can take your time to learn them. But effectively, we have new laws. Now, there are experts who have said that this will cause confusion in our courts, it will cause confusion in police stations. And of course, already the Indian law was cumbersome and large and difficult for people to understand. And this is likely to make it even more difficult. But are there any advantages to these new laws? Now, remember, these laws were passed in December in Parliament, in both houses of Parliament, with very little discussion. And now the other question to ask is, can there be anything done? Will they be referred back to Parliament, or is it going to be up to the courts now to tweak them piece by piece going forward? Also, I must point out to our audience that we have not effectively changed our criminal laws. Even after the British left, we sort of just adopted what was already there and made a few tweaks here and there. The government saying that this is largely being done to get rid of our colonial mindset. And we're going to talk about whether or not that is true also. Now, to help us understand and break this down, we have Mr. Sanjay Hegde, Senior Advocate with the Supreme Court. We're going to talk about how many cases are pending and if this is going to make it worse. And to help us understand what this is going to mean for the policing system and for individuals in society, regular individuals who might find themselves accused of a crime, dealing with cops and lawyers, we have Mr. Yashovardhan Azad, who is the former Special Director of the Intelligence Bureau, and he holds many other designations, but he's really a cop of tremendous integrity, and I've always enjoyed having conversations with him. He's had time to join us as well. For our audience, please ask questions because this story is about you. This is what will affect your daily life. Gentlemen, thank you for joining us. My first question to Mr. Sanjay Hegde is this: what will be the impact on the judicial process? We already have 83,000 cases pending. Is this going to cause more confusion?
Well, you see, before any legislation comes about, courts have said, why don't you take a judicial impact assessment? How is it going to impact judging? Is it going to speed up the process and all that? Nothing of that kind was done with respect to this kind of wholesale change. And given the fact that our courts are grossly overburdened, we have about 15 judges per million population, whereas developed countries have nearly 100 judges per million population. This wholesale change of laws, the fights over what each section means, though about 80% of the sections are the same as they existed in the previous law, but their placement has changed, their numbering has changed, whether that impacts their interpretation. All questions are up for at large, and till there are authoritative pronouncements that no, this section means just the same thing that it meant the past time, or no, this section means this with these variations, the law will not settle. We have, as of now, unsettled a lot of settled law, or given people a chance to reinterpret old sections as well. I think that there is going to be an explosion of cases, of the number of cases, and the system throughput is going to suffer greatly, at least in the initial years.
So here's my question, Mr. Hegde. Is the new, I mean, there will be confusion when switching from one system to the other, but is, in your opinion, the new system better in any way? Is the change worth it?
I doubt. I have no empirical evidence to say it would be better. What I can see is that many safeguards have been taken away. More discretion has been given to the police. So, let me explain it in terms of a cricketing analogy. We've just won the World Cup. Now, let's imagine somebody took it into their minds that cricket is, after all, a colonial invention. Now we have to Indianize it. we shall rename it, what shall we say, Balla Chendu. Okay? There will no more be runs, there will be dots, etc., etc., etc. You make all those changes, fine. But if you were to also say that as long as one side, namely India, is one of the players, they are allowed to bowl bouncers, beamers, everything, and the umpire shall not call it white. Will have to allow it. Will not have to care. You are systematically changing the delicate balance of the game, and I think that is what is most likely to happen out here. There is there's a whole host of individual hard fought liberties in the courts which
Yes.
are likely to suffer. And the most evident example of it is that now the police can take your custody for 90 days, and that 90 days is also not to be taken in one consecutive stream. That is, if you were given custody of on day one, it's not that your police custody can end at on day 90, because the police can very well take you for 5 days, return you back into judicial custody, take you again, and go on and so forth. And in a sense, maybe evergreen the process of police custody so that the final settling into judicial custody, after which bail applications are normally heard, that gets delayed. So I think the balance has gone awry.
The balance is out right now. Mr. Azad, here's the question. There are various articles. For example, The Hindu wrote an article about how the judges in Delhi High Court have been going through training. We know that the Supreme Court, there was a Supreme Court judgment on training of our police officers years ago, and that training never really happened. What is the level of confusion that is likely to play out in police stations where FIRs need to be registered, where the rules of how an FIR is registered has now been changed, saying that you have to conduct a preliminary examination. These police custody rules are changing. Is this going to cause a lot of confusion, sir?
Yes, I think 6 months' time is a short time for the entire system to adjust. Mind you, you have 800 police districts in this country, and you have 28 plus 8, states and union territories. So I think the three issues which I look at which are very, very important. Number one is that you have cast upon the police a huge responsibility. For example, you have said forensics are very important. I'm talking about technology. I'm talking about the positive aspects first. The technology playing a greater role, forensics playing a very important role in great crimes. Do you have the number one,
Yes.
infrastructure? And number two is the absorption of technology. These two are ailing top economies. We are even talking about absorption of AI, artificial intelligence, and what is going to happen. And here we are talking about something very basic. Can you imagine, Faye, that now that from July 1, the new cases will be registered under the new criminal laws? Do you have those 800 police districts where you have the forensic science experts to carry on that level of mapping evidence and presenting it to the court? Do you know that in Delhi alone, you need 700 forensic scientists to be able to cope with the kind of crimes you have? So that's number one. Number two, the problem which I have is that the so-called, if you're talking about a change, the change is what? Any law should be for the public. It's not for the handlers. It's not for anybody else. Every law in democracy has to be for the public. So, the people like Mr. Hegde and we have been talking on channels and platforms that how sedition is an outdated concept in democracy. Now, if you bring sedition through a back door under 152 and say now it is treason, and so anything can affect the sovereignty and in the integrity of the country. Anything can, you can make it anything. And again, you have the police powers to that. And number three is that whenever we are talking about these reforms, because in the criminal justice system, you can't put a jet technology on a bullock cart. Unless you have a prison reform, unless you have the internal police reform, and as you said, one of the very important components is training. And unless you have the judicial reform, and I absolutely agree with my friend Mr. Hegde about the impact analysis which should have been done before. So, looking at these three things, I would say that yet there is time. I mean, it's not like a hard and fast rule. Nahi, hame aaj hi se shuru karna. The Home Minister, for example, announced that nahi, that is only 15-day remand. The wording is so ambiguous, I'm still battling with it. I also thought that it's a 60 to 90 days and remand at various times. It will make a joke of the entire policing system. We don't want it. It's a nuisance for us also to keep bringing people in remand. So all these things need to be clarified. And I think wider consultations with greater consensus will help everyone, the ruling party, the opposition, the people, and all the stakeholders in the criminal justice system.
So here's my question, gentlemen. We know, I mean, interestingly, the opposition is really putting the government on the mat in parliament of various things, but not this. This has not come up, Mr. Hegde, in parliament. What is the route if like Mr. Azad says, it requires more deliberation, it requires more feedback, it requires clarification? What is the route to that? Is it just the courts, or can parliament still bring this up?
Parliament which makes the law can always unmake the law. But you see, now that it could have had so much more leeway had these laws not come into effect. Now, even for a day, they have come into effect. It can't be that the courts say, stay this law. Because if the courts stay this law, then there will be no other law. The previous law stands repealed. Yeah. You can't go automatically back to the IPC, CrPC, which existed previously. So it will now have to be examined case by case, judgment by judgment, and court by court. Two constitutional courts, a high court in the south and a high court in the north, may take different views of the same section. And then it will have to come to the Supreme Court for a definitive pronouncement. So I do not think that there is now a silver bullet. It has to be, and there would have been a silver bullet had the opposition taken it up more strongly earlier. And I do think we lawyers and our lawyer associations were also a bit remiss in this, because the full impact did not hit everyone, and all this has come in when many of the courts are on vacation and lawyers are on vacation. If this had come in, say, somewhere in the middle of a court year, and some set of lawyers or the other had protested, then it may well have forced all professional associations to take a hard look at things. Right now, we have had letters from individual lawyers. We have had even bar council saying, do not go down the route of protest, but we are trying things. And unfortunately, I think we have missed the bus as far as a stay is concerned. Now, as far as a blanket relook is concerned, now we'll have to look at it clause by clause. And I think the most obnoxious clauses, if put into effect in a concrete case, should be immediately challenged, and then the courts need to read it down.
Well, let me take this piece by piece on what could be the most obnoxious clauses in these new laws. Terrorism and the various things that have now been included in the terror, in the Terror Act, including now sovereignty, security, economic security of the country, acts intended or likely to strike terror among people. This seems really vague, and it seems like it's giving a lot of room here at the police level for arrests under UAPA for interpretation, Mr. Azad. It seems very mischievous to me.
I think
Effectively, they could pick up someone who's protesting tomorrow saying you are endangering this country and throw that person in jail indefinitely.
I totally agree. This kind of definition, which can be at variance, once a definition has already been given in the special laws like the UAPA and other special laws, you're again trying to put them in your new criminal justice. And mind you, in UAPA, it requires a sanction. In the new criminal law, it won't even require any kind of a sanction. Any policeman can just go and institute a case. And that is exactly the most important issue, which needed to be debated earlier. That what are the kind of, first of all, there was no need to define it again for creating confusion. Number two, it gives rise to various speculations and various interpretations. And therefore, number three, it is likely to be misused by the authorities by using the police to institute cases because it is so ambiguous that anybody can use it, as you said, in the name of economic security, threatening the integrity and unity of the. That is exactly what the debate was against those harsh laws, which we are debating in the preceding 6 months or last year. And that's exactly what we have. That is why when Mr. Hegde talks about clause by clause discussion, it's extremely important because then only we'll be able to expose the deficiencies and the redundancy of many other things here. And one thing I want to add, Faye, is that this reordering is going to be a nuisance. It is not that the law has been absolutely changed and decolonized and everything. More or less, it is the same. If we had at least kept the same numbers, then a lot less of this nuisance and ready reckoners and all that would have been required. And it's going to be a huge, huge issue. You're on the mute.
The police, forgive me, in its training, especially in local languages, on which section applies, what numbering of that section, it's almost a lot of that training is colloquial. A lot of that training will have to be redone. What is that going to cost in efficiency?
Well, in Delhi, for example, at different layers, the training has been done. It has been done for the constables and head constables. Then it went for the inspectors. Individual DCPs are doing it. Then they have been given these mobiles, the ready reckoners. But it will require a huge, huge amount of perseverance and a huge amount of coordination too. Because they have been given mobiles also for photographing and all these things have to be coordinated. So it did need at least 3 to 6 months more to do it in a proper fashion. And yes, training will continue. It cannot stop.
Mr. Hegde, the idea that one can be arrested for threatening the economic security of the country or for doing an act that is likely to strike terror among people, or even using financial means or encouraging feelings of separatist activities, practically applied worst case scenario, what does this mean on the ground? How could they use this against an ordinary citizen if there is malice to do so?
Well, you remember about a year ago when Adani Hindenburg came about.
Yes.
And the follow-up stories. Now,
Yes.
if at that point of time these sections were available, do you think that a policeman somewhere back of the beyond in Jumri Talaya could not be persuaded to take a view that this was economic terrorism? And you pull out any kind of journalists, financial journalists from Bombay who are doing stories and say, okay, please come to Heartland, India and explain yourself. I'll come to. So there are so many of these overbroad sections which will need refinement and strict enforcement. we were talking about sedition, right? Sedition came in during the British times. Then we became free. Then we had a constitution. Then came the question: how is the sedition section constitutional? It was only in 62 that the Supreme Court finally answered that question, saying that no. It's only if immediate violence erupts as the result of any such expression of thought, then you could possibly sustain a prosecution under this. So the Supreme Court had to refine it. It took nearly 15 years in those times. Now, by the time a case is launched and then it is fought and comes all the way to the Supreme Court, I don't know how much time it's going to take. And in the meanwhile, the executive will have a field day.
Mr. Azad, you wanted to say something? Go ahead, please.
Yeah, the other thing which I feel very strongly about is, why have you UAPA pretty well, you have a definition of terrorism.
Yes.
If somebody blows up pipelines, if somebody attacks the, economic security of the country that way, terror financing or anything, he can easily be dealt with under UAPA. And there is a procedure, there is a method, you need a sanction, there is a board, advisory board, all that. So by doing this, is there a design behind it? I can't say. I can't say there was a design behind it to deliberately do this. It's one redundancy, and the other is a waste of time. So why are you doing it? The government should at least explain this. And these are the things exactly on which the discussion was required. Let the government establish their case and say why we have put it here. That one sub-inspector can issue this case. UAPA was not sufficient. This has become laughable. That is why this case was very, very important. I'm glad Mr. Hegde discussed it.
Yeah. So effectively, if I'm not mistaken, for our audience who's asking, if tomorrow there's someone who writes an article and the impact of that article is that the stock market crashes, it's likely, in a broad and liberal sense, this particular terror act can be brought against this one individual. Tomorrow, if somebody protests and blocks the road and causes a traffic snarl, it's likely that a terror act could be brought against them. This has now become, so for example, the farmer protests that we've seen, the CAA protests that we've seen, various journalists doing their job. Can UAPA now be stretched, or can the new form of sedition, which is effectively treason, be stretched to apply to all of these people, Mr. Hegde?
Can it be? Maybe finally the courts may say, no, it can be used only in this. The courts may refine it. But will it be? It will be. Because when it is, as Mr. Azad says, available to a sub-inspector of police in any of the 800 districts in India to use, then how are you going to police the policeman at that level? And it will not even at least hitherto, when you had great injustice, you had great ministers who directly or indirectly gave a command. Now, if you devolve power down to the sub-inspector, any local political tough is likely to say, okay, fix this person, fix that person.
Yeah. And Mr. Azad is very kind, and he's saying, I don't know what the design is, but let's just look at the last 10 years of pattern, Mr. Azad. And let's see if we can see a pattern. We've seen student leaders who have been put in jail. We've seen journalists. We've seen dissenters of various forms who've been put in jail, where the Terror Act, the nature of the Prevention of Money Laundering Act and the Terror Act is written in such a way that it just becomes impossible to secure bail. Just the process itself is that punishment. So what we have here is a law where up until now you needed permission from a court to bring the Terror Act against a person, but now a sub-inspector can decide that you are a terrorist and you go to jail without bail, and then you go from court to court to court to court before you reach the Supreme Court. A few years have passed and you've rotten in jail till then. There's also now the question of the zero FIR. Mr. Azad, could you explain to us this change of the zero FIR and how that's likely to play out on the ground?
Yeah, I will. But I want to get back to that point which you mentioned earlier, because that's a
Yes, please.
very, very important point. Arundhati, after 15 years, is being prosecuted for something, and Supreme Court, something very serious, whereas Supreme Court clearly said that that danger, which we are talking about, which the Sarkar says, should be imminent and should be, should be visible. And nothing like that has happened in the last 15 years. And yet she's being prosecuted under, something as devastating as terrorism. So
Yes.
this is absolutely possible. And that is, at this point, I always bring out in any discussion that unless there has to be some kind of autonomy in the police functioning, none of the policemen on their own will be interested in putting a terrorist act against somebody. What for? They don't have any political designs to execute. So it is coming all from somewhere else. And if it is coming from the political regimes, unless you have some kind of autonomy, this is going to be a serious, serious issue. And that, of course, is a separate and a huge debate, which we can discuss later. On to the point of zero FIR, I mean, per se, it's excellent. There's no doubt about it. There are only two things. One is, India, there is a propensity to talk more, to complain more. And with this freedom of zero FIR, you'll be getting lots and lots of FIR. They will multiply like, it'll be a mushrooming. It'll be like atomic bomb, floating all over. So if you had one in a police station, you will have 100. That's one. Number two, at the same time, when you have between 3 to 7 years, those complaints which are coming, and the SHOs of the police stations having the power to do preliminary inquiry, unlike the Lalita Kumari case where it was only done for essential cases, it will lead to a lot of issues, a lot of problems, because these will become mediation centers, the police stations. So unless you have somebody, I don't mind if there is a Supreme Court lawyer or somebody very respectable at the mediation center where the police comes with an inquiry and both the sides are there. Otherwise, it's going to be a huge problem.
So
And
let me
yes.
see if I've understood this correctly for the audience also. So right now, as the law stands, as soon as I feel like a crime has been committed against me or against anyone else, I go to the police station. I tell the police station the policeman what I have seen. And that is my first information because it's freshest in my mind at that point.
Absolutely.
That has to be by law recorded in the police station in a diary. It has to be maintained that such a person came in and said this. I have to sign it after it is read back to me. And then the police begins its investigation. Thereby, there is a record of that first information. Now, as per the new rules, if an individual walks into a police station, the police can or should, I'm not clear about that, conduct a preliminary investigation of its own, and only after that preliminary investigation throws up any evidence or reason can they file a first information report. So in my mind, as a journalist, I know that this will mean that A, the police will kick out anyone who is not powerful enough to actually get them to do the work. They will secondly tell a lot of people, court kacheri ka chakkar katna padega, ab mat karo, ab jao. The third thing it will do is it will bring the two parties together and will say, why don't you just like sort this out among yourselves so that I don't have to file the FIR. A lot of people who are going to actually get hurt by this are people from oppressed caste, women who are filing domestic violence problems, women who are filing rape and sexual oppression problems. These are the issues that we have attempted to climb out of for the last 50 odd years, and we're going to find ourselves right back where we started. Mr. Azad, is that correct in your mind?
One of the biggest problems I feel, Faye, in this country is that small issues are not resolved. Small issues are just pushed under the carpet. But these are small things which hurt Indians. I mean, how many Indians have huge problems? They have very, very small problems. And these are always pushed under the carpet when you go to a police station, when you go to a municipality. Somebody's, sunlight is blocked by another window. That's a huge problem for that poor family. That can never be resolved. I have seen it as a Central Information Commissioner, the cases coming to me, the municipality. And municipality said, tell me what should we do? What is the law about it? So there is no law of torts in this. If you give somebody 1 lakh rupees, he doesn't return it. No matter what you try, you can never, even when you have the check case or any other case. In this particular case, I feel, these small issues, there should be some kind of an adalat, lok adalat. I don't know. Mr. Hegde can suggest that these small cases which are brought to the police station, I wish there is some respectable, community over there which can, take care of these problems. And I'm telling you, 60% of the issues can be resolved. But there was a low adalat system which had come up earlier. So I don't know what can be done, but this is going to create a nuisance in the police stations. Watch my words.
Mr. Hegde?
Well, in the early days, you had honorary magistrates, the honorary magistrate system, which would look at petty cases. And the local elite or people with some kind of sense of social service were appointed as honorary magistrates. I don't see why each police station should not have something like that. Or
But, one second, gentlemen, we are also, when we talk about FIRs requiring preliminary investigation, this is also when the police feel that there has been a crime or the complaint involves 3 to 7 years. So these are not petty crimes we're talking about.
No, I was responding to Mr. Azad's point.
Yes.
See, Lalita Kumari was with regard to cognizable offences. So where there is a cognizable offence, which is a serious one, the police have no discretion, had no discretion. Now, there is an element of discretion which has come even with regard to crimes where custodial sentences can be ordered. But Mr. Azad was talking about the other problem, which also which takes a lot of police time, and there somebody outside the police system, but with some judicial training or judicious training also, can be trusted to sort out things. So it is in that context I was speaking of the old system of honorary magistrates.
So I know that we had asked both of you for half an hour of your time, which I have now run through very quickly. But I do want to ask you this. What do we do now as citizens? Because there is no blanket stay from the Supreme Court. This thing is now effectively in place. There will be confusion. Mr. Hegde, another question that's popped up is, this is obviously not retrospective. So what happens to the cases that are already in courts or that are already pending right now? Which section will apply to them? Does that change?
No, it doesn't change. Anything that has been recorded or initiated before 30th of June, before midnight on the 30th of June, will continue according to the old system. It is anything that happens after midnight on the 30th of June and the morning of the 1st of July, that will proceed under the new system. However, there just might be, to my mind, I have to examine. Supposing there are penal provision, there are punishment provisions which are more liberal in the new law, then at the sentencing stage, maybe some way will have to be found, and there are judgments under interpretation of statutes which say that the benefit of liberal punishment statutes should be given. So if things can be sorted out with the say community service instead of imprisonment, all those benefits may just be available.
So there is an article that Indra Jaising authored for the Indian Express, in which she said, in every case it may be argued, if the new procedure negatively impacts the accused, disputes will take their own time to reach the Supreme Court, because um, procedural laws, unless they are negatively impacted on the accused, cannot be retrospective. So there's some room for interpretation that might cause further confusion as well, because lawyers will take advantage of that loophole if they can for their client, as is their job, which means that the pendency could actually go up even further. We'll delay our courts even more. Mr. Azad, go ahead.
Yes, I think lawyers will certainly use that, and why not if there's a more liberal, presentation on that. And that's why I think once for all, Supreme Court will have to give that interpretation that this should be available to an accused. So on this particular point, I think Indra Jaising is right. There'll be a lot of cases, and once for all, if Supreme Court gives a decision, that will be a good thing.
So at this point, my question to the two of you is, what can we do as citizens? Because is it up to the courts? Is it up to Parliament? Is it up to the bar associations? Is it up to the Indian Police Association? Where is the relief going to come from, or where is the appeal going to come from? And we're just sitting ducks in the meantime as citizens.
No, relief will have to come only if Parliament can be either forced to give relief, or it is in Parliament's interest to give relief. So it is up to citizens to raise their voice. It is up to the bar associations and judicial thinkers to say that, look, this particular section causes this problem, this, and it may well be that if sufficient pressure comes from within the ground and politicians have to respond to it, that there can be a response from Parliament. Otherwise, what will happen is, this is my prediction, that the chaos of demonetization settled down in about 6 months. GST has taken longer, but the chaos that this will cause will work its poison through the system for the next couple of decades. Lawyers will retire rich, especially those who sit and quietly read these laws and mark it away for use in the future. And young lawyers who are just coming into practice. If you start studying this very carefully, you will have an advantage over those who are already there or who are stuck in the old patterns.
Mr. Azad, with policemen with slightly malleable morals may also become, richer, given these laws.
Well, let me say two things. One is the Parliament, will it intervene? Parliament only intervenes when the representatives want, and representatives would intervene only when the vote, they see anything with the votes. I don't think anything matters in this particular case, so I don't think they'll be interested in it. The other thing is, as regard policemen are concerned, I always believe in one thing. If you post the right man, there is no problem. If you post the wrong people, there'll be issues. Now, according to the system today, and which should have been adopted, if you have a fixity of tenure and if you put a good police chief, the system will run beautifully. And why? Because that will take care even of the false institution of cases against people on political grounds, because there are still many IPS officers who stand their ground and refuse to institute cases. They might be transferred. That's a different thing. So one thing which can be done is that, as you said, the civil society standing up for the right people, for the right causes, and one should. There is nothing, to be very, very disheartened about. Today, I mean, there are lots of groups of people who are raising their voices on various platforms. And if this continues to be raised, and I'm sure there'll be a lot of these old issues coming back to the Supreme Court for interpretation and for giving a decision. And you might see all these sections coming up again, 195, where imputation and assertion of the kind which may hurt the sovereignty and all that, and section 152 coming back to the Supreme Court, and Supreme Court again. Actually, that was a violation. That's a contempt of Supreme Court proceedings, I would say. I don't know how Mr. Hegde would look at it, because once you had completely dismantled something, put it in a different way, you put it back again. I mean, it's something which will again go to SC, and we'll see the result also.
No, I'm also smiling because you said various parts of social fabric will raise their voices. These laws can be used against them at this point. So I don't know how much raising of voice is still possible at this point. It also seems to be particularly targeting protest. It does seem from the face of it that these are laws that do not encourage protest, which for me stands against the very fundamental fiber of our country, because we were a country born out of protest, out of peaceful protest, and to actually write laws that are anti-protest, I think, is anti-Indian. But is that an argument that will stand in anywhere, Mr. Hegde? And I'll take final comments because I know both of you have to go.
Well, the wisdom of the legislature is not up for challenge in the courts. Courts don't look at legislative wisdom. They look at adherence to procedure.
Yeah.
They also look at adherence to the fundamental rights of the citizens. So, as I told you earlier, the balance has been disturbed, and you are right that if people get scared and shut up, then not only will nothing change, the balance will move even further against them. I think it was Benjamin Franklin who said that those who would trade their liberty for a little security will get neither liberty nor security.
Mr. Hegde, can it be argued, forgive me, can it be argued that these laws are infringe on at least 3 different fundamental rights: to expression, to protest, or maybe some others if we spend some time on it?
21
Yeah.
are the right to life and liberty, that you cannot take it away without a procedure established by law. The Supreme Court long ago in Menka Gandhi's case said that the procedure must be fair, just, and reasonable. So will this pass the test, each of these sections, when it is applied in a concrete case? I doubt. That's why I said that, a public interest litigation may not be sustainable, and courts may be reluctant to go into it. But when there are concrete cases, if somebody becomes, and I'm sorry to use that phrase, a martyr of the Constitution, that is when courts will be forced to look up. But I do hope that people speak up adequately. There is enough pressure on politicians to say, look, this is something which is a vote loser, and we better look into it.
Mr. Azad, your final statement?
I would say that now that we have it in place and nothing much can be done about it, the few good men in all sections of the society will definitely stand up. And I have great belief in the system, because whether it's the cops, military, lawyers,
Good
everywhere.
Good women, sir.
Yes, sir. Sorry.
I was just going to say, and if they don't, the women will. So
men means men and women. I should have said women, because laws also.
We're teasing.
And 30% they have already stood up. And in this particular case, that's exactly the way to go. And if we do that, then I think we'll have the proper system in place.
Very powerful arguments here. I do recommend that all of us spend more time reading these laws, because, like I said, they affect our daily lives. It's not something that's happening at a parliament court level that's not going to affect us. This is really personal. This is going to, the last set of laws were with us for 100 years. So if we don't pay attention right now, we could be stuck with this for a very, very long time. Gentlemen, thank you so much for spending time with us and helping us understand this massive change. No doubt, as I checked the headlines on mainstream media, this is not the headline. This should be the headline. This is huge, what has happened today. This is what we should be paying attention to. And we hope that the good men and women of civil society, of the legal fraternity, of the police, the retired the IPS Association as well, start raising their voices about the confusion this is going to create in the 6 months or the years to come. Thank you so much for speaking to us today.
Thank you.
Thank you.
Thank you.